Today we're talking about a particular subsection of this business of the duties of the directors, the particular area of conflicts of interest, which is kind of mind-blowing in how simple it is and how people keep engaging in violations and getting sued left and right. It's just, you are supposed to go through this material and learn what is expected of the board and the variety of civil and criminal consequences that can plague directors who flout these rules. It doesn't stop them from doing it, but there you go. So we're talking about conflicts of interest, various duties of disclosure, and we're looking into the consequences of the breach of this section of directors' duties. Brief summary of the various duties of the directors. Really unhelpfully, everybody keeps obsessing about the labels of the duties and gets confused as to the substance. And I don't like the way that these things are presented in the statute book, but there you go. I mean, nobody likes the way the statute book is done anyway. But I don't even like the way these are presented in the textbooks. I find it confusing. This is the sort of brief list of what are the duties. They stay within their powers, so they're given specific powers to operate. They're supposed to stay within those boundaries. They cannot do whatever the hell they want. So the idea of you being the boss and doing whatever you feel like, old-fashioned thing that led into trouble that the new rules are trying to address. You're given specific powers. You're meant to stay within those powers. And not only that, you're meant to exercise those powers for the purpose that they're given. You can authorize payments out of the accounts, great. It needs to be related to company business. So not only you cannot exceed those powers, also not exercise them for capricious and what reasons you want. Secondly, whatever it is that you exercise of those powers, if you're a director of a company, you need to do it in order to promote the success. Overarching objective all the time is a good thing to do for the company. What you're doing is to benefit a friend, to benefit some relative, or to benefit yourself financially. You are not acting in the interest, you might get yourself in trouble. Understand the notion of what counts as success of the company. Gonna make the company richer or not? Also, directors have the duty of independent judgment. They cannot contract part of their functions to various managers. They cannot say, I don't know about this, it's another guy who's looking at this, so that's me. They cannot detach themselves. They want to detach themselves, they should quit from being directors. As long as you remain a direct obligation to participate in what's going on, accepting the fact that some stuff you're more good at that than others, but you can say, I don't know anything, I'm not looking at it, therefore I'm not responsible. You will continue to be responsible because of this. Whatever it is that you're doing, you need to do it with reasonable care and skill and diligence, and we've seen how this is defined in particular ways, how you've got an objective test in determining somebody is negligent or not, and how this has now in the statute a subjective top-up, meaning that if you know stuff and you've got particular attributes, it gets worse for you because more is expected of you. So there's a kind of bottom to this. Everybody is supposed to behave like a reasonable person with reasonable skills, but if you are an expert in an area, then you're going to be judged against this higher standard. If you fall below, you're negligent, you're violating the duty in 174. So these things from 175 onwards, they are the sections that deal with conflicts of interest, self-dealing, all of that stuff that becomes more personal. This up here was stuff about people who are incompetent, mostly. People who cannot stay within the powers or do the wrong things, or they don't think about what they're doing, or they don't participate in decision making. This is usually a lack of competence and negligence and recklessness as about against evil intent. What you got further down here in the no conflict provisions from 175 onwards is people who are engaged in something nasty. So not only they're doing something wrong for the company, but they're doing it for a reason, the reason usually being to personally profit. Yeah, so it gets worse. So what we're looking at is a series of all these things. Moving on from the fiduciary duties that I just explained to the discussions that come under this heading of no conflict. So the directors are obligated to not engage in self-dealing, so they must not profit from transactions with the company themselves. They must not profit from the personal exploitation of the company's property, information, or opportunity. and they must not get benefits from third parties. So all of this is an expression of the fiduciary duties of the directors. As we've said before, fiduciary duties are obligations that stem from a relationship of trust and confidence. So we usually have a distinction between common law derived duties that are contractually determined, moving to equitable style duties that are more relationship based. So if we're talking about fiduciary expectations that are coming out of relationships where there is a base of trust and confidence, you expect things of the other person, not simply because you have a contractual relationship with them, but because your relationship in itself is something significant. Because of this, of their position as fiduciaries, the directors cannot put themselves in a position where there's a conflict between their duty to the company and their personal interest. They need to exercise good faith. We've seen this already in sections like 174, but it's not simply a matter of saying that directors are taking decisions in a non-biased way. Okay, the interpretation of those fiduciaries than that. If you want to sort of identify the core of these no conflict provisions, I think the best place to start is the idea of the prohibition of self-dealing. The directors must not make personal use of the company's property, information, or opportunity, and they're not required to receive benefits. We identify a situation as self-dealing when the director is in some sense on both sides of a transaction with a company. What happens if a director sells his own property to the company? This obviously creates a conflict that you can understand. If I'm selling my property to my company, how much is the company going to pay for it? I'm trying to get a good deal for myself as I'm parting with this, but I'm also trying to get a good deal for the company. The idea of fairness when you're on both sides of the transaction can be tricky. It can be difficult even when people are trying to do the right thing. Majority of these cases that end up in the courts are not from people that are trying to do the right thing. They're people who are thinking, oh, wow, I'm going to sell this stuff to the company for a fortune. So, I put all the nice cash in my bank account. A direct sense of self-dealing would be this, that there's a transaction involving the director or a family member of the director or somebody who's connected. Very often you get into trouble with exploiting company property or company opportunities. Exploiting company property could range from, just using the company's credit card for your Black Friday shopping, which is like an obvious violation because you're not acting in the interests of the company when you're doing that. Secondly, you're violating the mandate. You're violating the powers that you've got because the powers were to use the credit card, but not for personal expenditure. Plus, this is a type of self-dealing. It's like you're stealing money from the company. When it comes to the exploitation of opportunities, if a valuable opportunity arises, then it is your job as a director of the company to convince the company to exploit that opportunity. It's not for the company to pass it by and then for you to take it upon yourself and make money from it. You come across a shipment of goods that your company could be selling and they're at a great price, so you could buy them and sell them much more expensive through the company, and you choose not to do this, but you buy them yourself and you put them on eBay. You exploited something that came across as a valuable opportunity for the company. You chose not to exploit this through the company and you exploited it for personal gain. Because you're a director, you are not allowed to do this. Equally, as your obligation is to make decisions for the benefit of the company, if you accept a bribe from a third party in order to take a particular decision or steer the company in a particular direction, then you're engaged in a violation. If the company is looking at various types of procurement, you're looking at, where to get your toilet paper for the office, and somebody comes along and says, if you put an order for us, I'm going to give you a free iPhone, and you do it for that reason, then obviously you are accepting a bribe from a third party for personal benefit in order to get the company to engage in a transaction that is perhaps not beneficial. These conflicts, these opportunities for trouble, and these arguments have been going on for a very long time, and very understandably, because this is human nature. A good case to start with is the case of Aberdeen Railway versus Blakey. It's a case from 1854. Now, it's that a corporate body can only act by its agents. we know this. That's why the directors are the kind of minds in the hands of the company. The duty of those agents is to promote the interests of the company whose affairs they're conducting. These agents have duties to discharge. These duties are of a fiduciary nature, and they are supposed to discharge them in a way that benefits their principal, which is the company. It is a rule of universal application, the judge said, that no one having such duties to discharge can be allowed to enter into agreements in which he has or could potentially have a personal interest which conflicts or could conflict with the interests of the person he's bound to protect and represent. So this is a very strict principle. It has to be addressed regardless of the fairness or unfairness, benefit or no benefit of the eventual transaction. That you are putting yourself in a position of conflict is a problem in itself. And what the rules are trying to do is not to check that in case of inappropriateness, the company is not damaged. What they're trying to do is to make sure that the director does not put himself in a conflicting position from the beginning. So you see, the level of control is much more significant than just checking that no harm is done. The level of control is that the agent should not be in a position of conflict. Now, there's been some case law on these things. We can use the case law in order to inform our understanding of how the statute, if you start from the statute and then you use case law as illustration of what's happening or as additional example, but your starting point should be the statute. This doesn't work if you're working through a problem question and you start from the label and you try to match the label to what you think might be going on. It should be the other way around. You read the problem question, you think about what's going on, and then you try to find a label that matches. Right? So read your problem question carefully and then go back and say, what does this look like? Does this look like somebody not promoting the success of the company? Does this look like some conflict of interest? Does it look like somebody is asleep and is not exercising independent judgment? So that's a much easier way to find the problem, identify the problem, find the situation, the heading, then find the appropriate statutory section. And once you found all that and you're confident, then you can look up some case law for additional illustrations or explanations and the rest of it. But it can be confusing because there's a degree of overlap between these provisions. And the facts in a problem question might look very similar to something that's happening in other of these sections. Yeah? What about things that require approval by the shareholders, right? So we discussed so far about making a conflict of interest disappear by making a disclosure to the board. But there's also an opportunity for disclosure to the shareholders. This has to do with, to a degree, avoiding conflicts of interest in 175, but crucially not to accept benefits from third parties, which is the bribes in 176. Some shareholder approvals need to be gained for property transactions as well. If there's a conflict situation that involves a property transaction, if it is significant enough, it is not sufficient to tell the other directors, you have to go to the shareholders. Now, why is this? Because it could be that the directors are all in it. It could be that they're all buddies and they kind of approve each other's inappropriate behavior. So disclosure to the board is not gonna cut it if there's a culture that says, okay, you've done something a little bit dodgy this time, we'll turn a blind eye, and when I do something dodgy, you do the same for me. So for things that are very significant and very destabilizing of the stability of the company or of the future of the company, then it makes sense to ask the shareholders, because it's their money at the end of the day. If they're happy to approve something, then fine. But you need to go a step further than simply asking the board. If we're a small private limited company and we are getting, a contract for the supply of toilet paper, that's probably not significant enough to go to the shareholders. But if we're buying a new van, if we're leasing new premises, this is a significant change in the way that the company operates or involves a significant expenditure. so then it will need to be approved by the shareholders. And again, what are we talking about? We're talking about stuff that link back to a director and create a conflict. I'm not talking about the directors wanting to buy a van and then having to ask the shareholders because they're responsible for managing. But if the van is coming from one of the other directors, then it's not enough that you ask the board, the other shareholders. As regards the consequences of violation, then we go back to what we said before, the civil type of consequence. If it has not been disclosed and approved, then the transaction is voidable if it regards insiders, and if it regards outsiders, then it is a matter of the director in each compensating the company for any loss that has arisen. Similar stuff you have for loans. If the company is to make a loan to the director, this requires the shareholders' approval. And we're talking about loans, but also other things that look like loans, like provision of credit, or facilitation for charges. This is very dangerous because you don't want a guarantor for personal transactions of the director or providing financial backing for the director. This is an obvious case of conflict. There's also an obvious case of conflict that can have significant enough board of directors. Why would the director want a loan? Why not? Right? You have, instead of getting the loan, what if you get your own company to provide the money for the thing at rates of interest and terms and conditions that would be much more beneficial from the bank. It would be awesome. At the same time, it is potentially a terrible deal for if you default. It affects issues of liquidity within the company and the availability of money and all of that stuff. Also, provision of credit. You don't want the company to be backing up or providing guarantees for the consumer spending of the directors. Okay? A director will be in breach of his duties when there is a conflict, regardless of whether the conflict had any detrimental effect, whether it had any effect on the terms negotiated in a transaction. It will be a problem regardless of whether the terms could be regarded as fair. Liability does not rest on a bad thing happening, it rests on the fact that the conflict exists. As regards determining a violation, the fact that the director is in a position of conflict is a breach of duty in itself. You don't have to wait to see a negative consequence. The negative consequence becomes relevant only when you're looking at the calculation of damages. Because of course, being in breach of duty is one thing, having an obligation to compensate is another, because that rests on actual damages having been suffered. If the rule is that you cannot be in a position of conflict, what are you supposed to do if a conflict arises? How are you supposed to deal with it? So you do your best not to get any personal transaction, company, all of that stuff. You want to do things in good faith. But what happens if you realize that this is something that will potentially cause trouble? Conflicts are resolved through disclosures. And that's the way the system works. Because the level of violation is at the existence of the conflict, the only way you can get around it is by preventing the conflict from arising, or if the conflict arises, by making an appropriate disclosure to somebody, the board or the director or the shareholders, to tell them about this. So they're informed. The logic is that if people are informed in advance that you will be in a position of conflict, then any decision taken will be taken with that in mind, so have extra effort in checking that the outcome is beneficial for the company. So where do you find these disclosures? Some of the disclosures need to go to the board of directors. Some disclosures need to go to the shareholders, depending on what we're talking about. So you need to develop a degree of familiarity with the underlying sections to be able to distinguish one from the other. So let's look at section 177. There is a duty to declare an interest in proposed transactions or arrangements. If a director of a company is in any way directly interested in a proposed transaction with the company, then he must declare the nature and extent of that transaction, of that directors. And this declaration can be made at a meeting or by written notice. Once you've made this disclosure, Could be that the company is interested in buying a piece of land and you're the owner of that piece of land. Or they are thinking, oh, we would like to buy a retail space. Who has retail space around? Well, one of the shops is mine, and I'm a director. So I need to disclose this immediately to the board. And this involves anything that the company is going to be negotiating that is contractual, but also things that are of non-contractual nature. The effect of this disclosure is that it puts the other directors on notice about this conflict of interest. It's also about indirect stuff. It's like it could be that I'm not the owner of the property next door, but my wife is, or my cousin is, or my kid is, or my dad is. This is an indirect interest. It still needs to be disclosed. Once you've done this, then you have absolved the conflict. So you are no longer in a position of conflict, therefore you are not in breach of your duties. What happens if you fail to disclose? So the company is starting to discuss about buying retail space around their shop, and one of the spaces belongs to my mom, and I don't tell them about it, right? What happens then? Then I would be in breach of 177, and the transaction would be voidable unless we're talking about an unconnected third party. If we're talking about an unconnected third party, then if the company has been damaged financially, then it becomes an obligation of the director to compensate. If the shop's mine, disclose the interest. This arises later on. I'm in breach of my duty. The company can ask to cancel the transaction. One potential remedy here would be to cancel the transaction, or if this has been financially damaging to the company, to pay some compensation, or both, depending on what happened. If the property belongs to a third party, if the third party is not involved, then you cannot ask to cancel the transaction, but the obligation remains on me as a director, being in breach of my duties, to compensate the company for whatever loss they've suffered. But this is only civil. Civil actions, we're talking about compensation left and right in the response to what has gone wrong. The consequences are not only civil, it can get worse. If you have an interest in an existing transaction or arrangement, so we're no longer looking at future stuff that the company is looking to do it, but we're talking about stuff that the company is actually involved in right now. It's something that I am in a position of conflict. I have not disclosed. Maybe I didn't realize it was going on, but now it is happening and I'm in it. What am I supposed to do now? Then you look at section 182. That says that where a director of the company is, directly or indirectly, interested in a transaction entered into by a company, they must declare the nature and extent of that interest to the other directors. Now, obviously, if you've already done it in advance following section 177, you don't need to do it again. How is this different from the previous situation? If it is happening now, and I fail to disclose my interest in what's happening now, then the consequences are both civil and criminal. Before, for future-looking transactions, the consequences were only civil. It was only an issue of cancelling the transaction or paying compensation. Now, it is that, and in addition to that, you have a criminal consequence, because section 183 makes it an offence fail to comply with this requirement, and if you're guilty of that offence, then you're liable to conviction on indictment, to a fine, or a summary conviction. Now, this would be a greatly funny. Let's take a step back and go to the overall provision, the duty to avoid conflicts of interest. So normally when you're having these discussions, it's probably sensible to start from a statement of the overall duty in 175, and then to discuss, okay, we have a conflict situation, what are we going to do about this? We're not allowed to have this, how do we fix it? Then we fix it through disclosures. The duty is there to avoid the situation of conflict. The area that has generated the juiciest case law is the area that has to do with corporate opportunities. Now, corporate opportunities are defined very broadly, and you have a list of nice, like Regal and Gulliver, you've got Industrial Development versus Cooley, CMS Dolphin, Buller and Buller. Why are these cases so great? Because they go to the heart of the idea that it's the obligation of the directors to act in the best interests of the company. It is not enough that the directors bring the opportunity to the knowledge of the company. It is not sufficient to tell the board, would you guys like to buy this? And the board goes, I don't know, maybe not. And you go, fine, all right, I told you guys, I thought it was good, you don't want to do it, I'll take it for myself. That's not how it works. Because not bringing it to the board and doing it on the side is obviously a problem. But also bringing it to the board and failing to convince them that this is a good opportunity, and then doing it for yourself is a problem. If you want to exploit a corporate opportunity, then you need to do your best. You need to put in a proper effort in convincing the board that this is a good thing for them to do, even if they don't feel like doing it. So if it is indeed such a valuable opportunity, it is your job as a director to convince them to do it. Secondly, if they keep on saying no, then you need to go through the disclosure bits to get explicit permission for them to allow you to do it. If you don't go through these two steps, then you will be liable to account to the company for any profits that you made out of this, because it will still be considered as an unresolved conflict. Quit in order to go and exploit that opportunity. Because that would be easy, wouldn't it? I mean, you find like you hear of a great deal, then you quit from the board, then you go and do it yourself. Now, what happens with the idea of conflicts of interest that are created by you having multiple jobs? Now, this could be an issue here. People are directors in multiple things at the same time. You know, high-flying executives, they could have an executive directorship in one company, and they've got sort of non-executive roles in a whole bunch of other companies. The problem is, if the companies that you have a position in the board are engaged in the same field of activity, when it comes to exploiting a corporate opportunity, which company do you take it to? If the companies are doing similar things, and you come across a good idea, if you present it to one company, then you're automatically in breach of your duty to the other, and vice versa. Even though there is no prohibition in being a director in multiple places at the same time, the practical implication is that you cannot be compliant with your role simultaneously across a number of companies if all the companies are doing the same thing. You can be a director in different companies, yes. You should keep the fields of activity distinct. We're not trying to criminalize the idea of multiple directorships, but the reality of the matter is that you need to fulfill a certain role and you've got obligations, and they will by necessity conflict. The thing that has to do with bribes in 176 is obvious. The director cannot accept a benefit from a third party based on their business. A bribe would mean that you're influencing corporate decision-making, and the reasons for your recommendations are because you got a bribe, not because you think this is a good idea. So there's a prohibition against this. What are the remedies we've already discussed? You can see in section 178. Be mindful of what I've already told you, the potential criminal consequence of not disclosing conflicts of interest for existing transactions. What is interesting is the idea of third-party liability. When does a third party become responsible in a way that can affect the validity of the transaction of the company and the third party when there is a conflict of interest? Have a look at these cases. One is Royal Brunei, and the other one is Twinsectra and Yardley, that help you get a little bit deeper into the idea of how do the third parties position themselves against problematic transactions that are tainted by some sort of conflict of interest.